Hello, my name is Benjamin Hart. I'm an American attorney and the Managing Director of Integrity Legal here in Bangkok, Thailand. In this video today, we're going to be discussing the Form G-28. The G-28 is specifically a form that provides notice to the Department of Homeland Security's United States Citizenship and Immigration Service that an attorney is representing a client with respect to a pending matter before that body. Basically, these are forms that someone like me, I often have to fill them out and file them with respect to a visa case where we have a client that's seeking a visa to the United States. It's something that should be noted is if you're not dealing with an individual that can file a Form G-28, you may want to go ahead, especially if that individual is holding themselves out to be a licensed attorney or someone who is qualified to assist. Well, I should specifically say to obtain remuneration for assisting with U.S. immigration matters. If they can't fill out a G-28 form, it's probably a good idea to go ahead and ascertain why that is. I'm not going to get into details specific to that, but it's probably not a bad idea to figure out why they're not able to file such a form if they're assisting people with these cases. So, I pulled this off the USCIS website directly. Revised May 23rd, 2012. It specifically, this specifically talks, this is from uscis.gov, specifically discusses matters pertaining to attorney representation and the Form G-28. I'm just going to quote directly a few, I think, fairly relevant passages here. And I'm paraphrasing a little bit. There's sections we're going to miss, but just some of the key points. An applicant or petitioner may be represented in matters filed with USCIS. Whenever an examination is provided for under the regulations, the person involved has the right to be represented by an attorney or representative before USCIS. Title 8 CFR 292.1 lists the categories of individuals who may represent a person entitled to representation before DHS, subject to the limitations in 8 CFR 103.2A3. An applicant or petitioner may be represented by an attorney in the United States, an attorney outside the United States, an accredited representative of a recognized organization. Only these categories of representatives may file a notice of appearance on Form G-28 or G-28I in an application or petition proceeding before USCIS. And just quoting further, attorneys in the United States. An attorney, quotes, an attorney is any person who is eligible to practice law in and is a member in good standing of the bar of the highest court of any state, possession, territory, or commonwealth of the United States, or of the District of Columbia, and is not under any order suspending, enjoining, restraining, disbarring, or otherwise restricting him or her in the practice of law. An attorney need not be admitted to the practice of law in the state in which his or her office is located or where the applicant or petitioner resides, and may have an office outside the United States as long as he or she is an attorney as defined in the regulations. Just as sort of a further commentary, because it mentions accredited representatives, to quote further, an accredited representative is a person who represents an organization that has been recognized by the Board of Immigration Appeals. And those are rather specific bodies, I guess I should say, or organizations. Things like Catholic Charities. There are various nonprofit groups, non-governmental organizations, NGOs, that may have been approved by BIA for purposes of assisting people in these matters. But again, accredited representatives tend to not be folks who can accept, in fact, I believe they cannot charge fees for assisting in matters pertaining to U.S. immigration. If I'm wrong about that, it's only in a limited scope. But that being said, just to put a fine point on it, those who are looking to undertake U.S. immigration to the United States, they can do it themselves. That's certainly possible. But if you're looking to have professional assistance, you need to go ahead and hire a licensed attorney. And you can ascertain that attorney's credentials by asking them directly, what are your credentials? And you can see the credentials as mentioned in there, you know, a license, a bar card, basically a license showing admission to the bar, the highest court of a given state, commonwealth, etc. So these are basically the things associated with the G-28. Once an attorney has become an attorney of record in immigration proceedings, they're going to go ahead and a big one is be copied in to the various correspondence associated with the case so that they can deal with things, you know, in a timely manner on behalf of their client. So basically, to sum up this video, the thing to take away, the G-28 is basically a form that's associated with attorney representation in the United States, and or I shouldn't say in the United States, attorney representation before the various agencies associated with the U.S. visa and immigration process. Those who are unable to produce some sort of licensure to practice law in one of the 50 U.S. states or jurisdictions of the United States, basically, pursuant to the law as noted in 292.1, it can basically be inferred that those individuals can't charge fees for assisting people in immigration matters. So to sum this thing up, the G-28, it's an important document. It places the government on notice that an individual or individuals or a company have retained an attorney and have representation in an immigration matter, and that attorney will be copied in and will be can act as a liaison, act as a representative as the case progresses.